Good afternoon, ladies and gentlemen, those in the audience and those on our Facebook page, YouTube channel, and the Anti-Baptist SCAN app. Welcome to today's session on estate planning. Could we stand, please, for a word of prayer? Let us pray. Father and our God, we thank you for who you are. We thank you, God, for your love and for your care for us. We thank you that you woke us up this morning in our right minds and that we are gathered here this evening. We pray, O God, for our presenter, that as she presents on wills and estate planning, that we may be receptive to what would be said, but that we would take it a step further and put into action what we would have gleaned this evening. We pray, O God, that you would be with all this evening's presentation and that everything will be done to your honor and to your glory. In Jesus' name, amen. This evening forum is organized by the Just Among Moms group of the Anti-Baptist Church. This is our third annual forum on topics that are relevant to the general public and are chosen to assist us in making informed decisions. In 2019, we discussed menopause. In 2020, the topic for discussion was diabetes and its challenges. And today we are here to discuss estate planning. A simple definition of estate planning is that estate planning is making a plan in advance, naming the people or organizations you want to receive the things you own after you die, and taking steps now to make carrying out your plans as easy as possible after you are dead. Estate planning is one of the most important steps any person can take to make sure that their property and healthcare wishes are honored and that loved ones are provided for in their absence. Today, Ms. Alethea Gumbs, Director of Legal Aid and Advice Center, will discuss the importance and benefits of making a will and putting our house in order so as to avoid mayhem when we leave this earth. We will have the opportunity to ask questions at the end of the presentation. We wish to welcome you to today's forum on estate planning. I'll now call on Mrs. Danielle Richards, who would introduce our speaker.
Good afternoon. Okay. Ms. Alethea Gumbs is a barrister at law and solicitor of the Eastern Caribbean Supreme Court. She was called to the bar of the Eastern Caribbean Court, St. Christopher and Nevis Circuit in 2006. Ms. Gumbs read law at the University of West Indies, Cave Hill Campus, Barbados, from 2001 to 2004, and was awarded a Bachelor of Laws degree with honors. After the three-year degree program was completed, she continued her legal studies and attended Norman Manley Law School in Jamaica and was awarded the Legal Education Certificate. Ms. Gumbs was the recipient of 2 prizes at the Norman Manley Law School in 2006. Prior to reading law, Ms. Gumbs was a banker for just over 10 years. While a banker, Ms. Gumbs undertook some studies and was awarded the preliminary certificate in banking from the Chartered Institute of Bankers in England. However, the law was always the preferred career of choice for Ms. Gumbs, and she stated that as a little girl of 7 years, she enjoyed the show Perry Mason and decided that when she became an adult, she wanted to become a lawyer. Alethea Gumbs combined her love of banking, finance, and the law, and read for a Master of Laws in the International Finance and Banking Law at the University of Liverpool, England, and was awarded with a merit. Ms. Gumbs is a director at the St. Kitts Nevis Legal Aid and Advice Center. This department falls under the Ministry of Justice and Legal Affairs and is located on West Independence Square Street. Ms. Gumbs says that her love for the law causes her to thoroughly enjoy her job, along with the fact that through legal advice, legal assistance, or legal representation, she's able to assist persons almost on a daily basis. Ms. Gumbs enjoys singing, reading, and listening to music when not at work, and she states that since COVID, she has become a TV member of Antioch Baptist Church. Ladies and gentlemen, join me in welcoming Ms. Gumbs to the podium as she speaks to us on the topic of estate planning. You gonna sing a song?
Good afternoon, thank you. I crave your indulgence a few minutes to just set up here, please. I hope you can see me over the laptop. The laptop is a bit low. Okay, the topic today, estate planning, is also known as the law of succession in our UK parlance. Estate planning is more a terminology that is more American-based. And for today, our focus will be on wills. And in talking about wills, of course, we'll end up speaking about an intestacy, which means when someone dies and they don't have a will. So first, I'm going to start by first giving a definition of what is a will. The legal dictionary states that a will is a document in which a person specifies the method which would be applied to the management and distribution of one's estate after their death. The Halsbury Laws of England, these are some laws that we depend on quite a bit for legal knowledge. And at volume 50, paragraph 252, it mentions that a will is normally made for the purpose of making dispositions of property to take effect on or after the testator's death. Now, a testator is the name that is given to the person who makes a will. Every will, therefore, has the essential characteristics that during the life of the testator, it is a mere declaration of his or her intention and may be freely revoked or altered in a prescribed manner until his death, as a will is ambulatory or without fixed effect. That is to say, at any point in time after one makes a will, they can go and they can change it. And you know, this is really important because sometimes you can make a will which specifies, I'm leaving this to my son or my daughter, and then somebody goes and that same testator perhaps, and tells the son or daughter, boy, you're getting the whole property. Next, the son or daughter might meet up with someone who, for some reason, causes the relationship to no longer be the same that existed between parent and son or parent and daughter. And because of that, the individual may realize, but wait, I'm not even dead yet. But the treatment changed since I told the person. And so that is why the will is ambulatory, in that at any point in time, you can go and you can make amendments to this will. And by making amendments, it is not that you just go and you're going to just cross out something or put in something. There's a procedure that this will entail. And we will speak about that later. So on the testator's death, the will crystallizes and takes effect as an appointment or otherwise according to its tenor, says Foss and Hemblin. Simply put, a will, therefore, is a legal document that allows a testator to specify how he or she disposes of assets when he or she dies. A testator may also dispose of an interest which may arise by way of trust and is merely equitable, such as his interest in property assets, assets in goodwill, or a partnership. And when we talk about equity, most of you in here would know about equity because we are not all millionaires so that we can build our house cash. So most persons would go to a bank and you will obtain a mortgage. And having obtained that mortgage, the bank then would be the legal owner of the property. Until when you make that payment, you become the legal owner. However, you have ownership in that property, but the ownership that you hold will be in equity. And so that is why dispensations can be made in relation to your property because you're an equitable owner of such property in the instance. Are you following me? Great. So then we move on to the fundamental question. Is a will necessary? The answer is yes. Provided, of course, that one has possessions, fixed or current assets, equitable interests, etc., so that one wishes to gift to a person or persons whatever he or she so desires. And we have to stress, provided that one has possessions, because, in St. Kitts, in our local parlance, if somebody is really, it's a 6-letter word we use mostly. It begins with B, it has an R, and it ends in S. So if you're broke, and you don't really have nothing much to pass on, then there would be no necessity for a will. And we like to talk about brokes here, but a lot of times people are saying they're brokes because financially they may not have the cash, but they may have the capital in terms of their own assets. And sometimes people have to pay attention to the fact that it's not just having cash or anything, it's about owning worth by other means, capital otherwise. The Intestate Estate Act defines an intestate. Did I miss something? Just 1 minute, please. Okay, so in answering the question, we'll just go back a bit. If the will is necessary, and we say yes, we've already outlined why it is already necessary, because if a person dies without a will, that person would die intestate. And under the laws of St. Kitts and Nevis, we have an Intestates Act, which specifies if you don't have a will, this is how your assets, your equity, your appointment of any persons in relation to your children, a trust that you may set up, this is how this will go. And it is done because it provides some measure of structure. Because if there is no order in our society as to how one would be able to know of one's right, then it will be mayhem. And so the Intestates Act provides a guide that one may follow. Now, this guide is quite a challenging guide, but we will look at it, and then you will then decide whether it makes sense to do the will or simply don't do anything and leave it, as the Jamaicans say, dead left. Meaning, you're dead and you're left confusion. And that is not what people want. You want to have that quality, that you lived a good life, and after you have your time come and you pass on, you can die and your assets are left to your loved ones. Now, when we speak about wills, it sounds sometimes quite morbid because we are thinking of death. But in life, there's always death. And so one has to be mindful that once one has assets, it's not about doing a will and you die. It is simply about making sure that if God forbid anything happens, the ones who you love and care for, your wishes in looking after them, that it's carried out. Because a will is known to be that of a testator who is speaking, we say, from beyond the grave. I know the minister might be wondering what nonsense that is. But it is just in our parlance that we say, in our legalese, that we say the testator speaks from beyond the grave. That is because his instructions have already been given while he's alive. And so even though he is gone, his wishes are being carried out. So we speak of the Intestate Estates Act. And that act defines an intestate as follows. It includes a person who leaves a will but dies intestate as to some beneficial interest in his real or personal estate. So you realize the person can have a will, but because there was something in relation to the beneficial interest that was not clear, the estate now becomes an intestate estate, and then they will require letters of administration instead of a grant of probate in order to administer the estate. The succession to real and personal estates on intestacy under Section 4 of the Intestate Estate Acts sets out that the residuary estate of an intestate shall be distributed in the manner or be held on the trust in the following manner. Firstly, if the intestate, that is the person who dies without the will, leaves a husband or wife with or without issue. In law, we refer to the child as the issue. I don't know why, but it's the terminology. So if an intestate, the person dies, you leave a husband or you leave a wife, you have no child. The surviving husband or wife shall take the personal chattels absolutely. And in addition, the residuary estate of the intestate, which is other than the personal chattels, shall stand charge with the payment of a net sum of $5,000 or a sum equal to 10% of the net value of the estate, whichever one is greater. And this is also free of death duties and costs. Permit me a minute so that I can refer to the act, which is more detailed. I know you don't want too much details on this, right? So we'll keep it just as simple as possible, but I still want to touch on some of the areas that I have just briefly put down. What happens is that the mere fact that the intestate leaves a husband or wife without issue is the first step under the residuary estate that one seeks to address. If the intestate leaves no issue, which is no child now. So first we talk about leaving the intestate, who would have, if you're following me, it's the intestate who leaves issue, correct? You following me? So if the intestate leaves a husband or wife but has no child, the surviving husband or wife will get the personal chattels. And under the Intestate Estates Act, let me define what personal chattels and the residuary estate means. The Act specifies that personal chattels means, because the Act is so old, listen to the first thing that it has. Carriages, horses, stable. Then we get to what we are accustomed to, furniture and effects. But these that are not used in business, motor cars and accessories. But they're not the ones that are not used in business. garden effects, domestic animals, linen, china, so the goods in your home, your furniture, even your wines, your liquors, your scientific instruments, articles in the household, these are deemed personal chattels. The residuary estate now, that means every beneficial interest, including the rights of entry and reverter. That means the right for you to enter into the property if the property passes to you, and reverter means that it can revert to somebody else. So once we know the Intestate Estate Act and the definition of residuary estate and chattels, then let's proceed, because you have an idea of what we are then speaking of. If the intestate leaves issue, I think I'm a bit behind with this, but no husband, just let me get on track with this. I think my slides are going ahead of me. Okay? If the intestate leaves no issue, that's where we are, sorry. Upon trust for the surviving husband or wife during his or her life, just give me a minute, something seems like it is skipped here. We are speaking of the residuary estate, and because we are speaking of the residuary estate, we are looking at the law of succession, and the residuary estate of an intestate shall be distributed in a certain manner. And the distribution is that if the intestate leaves a husband or wife, which we said before, with the surviving husband or wife, the personal chattels and these items of the residuary estate goes to that individual. The residuary estate also looks at if the intestate leaves no issue upon trust for the surviving husband or wife during his or her life. Also, if the intestate leaves issue upon trust, that is a child who is young and under age 18, as to one half for the surviving husband, that is how it's distributed, whatever is left, one half will go to the surviving husband or wife during his or her life, and subject to that life interest on the trust for the issue of the intestate. And so the other half of the statutory trust will then go to the issue. So the husband gets one half, the surviving husband or wife, subject to such life interest, and the other half of the statutory trust will go to the issue of the intestate. And remember, we said the issue is the child. However, if these trusts fail to determine in the lifetime of a surviving husband or wife of the intestate, then upon trust for the surviving husband or wife during the residue of his life, that would fail. Now, if an intestate leaves issue, so the person dies, if you leave issue, meaning you leave a child, but you leave no husband or wife, the residuary estate of the intestate shall be held on the trust for the issue of the intestate. So you have a child, but the husband or wife is not around. The child then, upon a trust, will get everything. If the intestate leaves no issue, so you have the person leaves no child now, but both parents, this is subject to the interest of the surviving husband or wife, the residuary estate shall be held in trust for the surviving mother and father in equal shares. So you see, if the person dies, they have no child, but the parents are alive, mother and father can get what they have in equal shares. Following me? Now, if the person who dies, again, the intestate, if by any chance now, they leave no issue, no parents, if there is a surviving wife or husband, the residuary, if there is a surviving wife or husband that is subject to their interests, the residuary estate shall be held in trust for the following persons. And here's how it goes. And this would be the following persons who were, of course, living at the death of the estate. So they had to be alive at the time when of the intestate. They had to be alive at the time when the intestate person passed. And here's how it goes. The first set of people then, after all what we said in relation to passing to the mother and the father, or the husband or wife, or the child, if all these other gifts are unable to pass because the residuary estate was in such a position that nobody else is claiming anything, the first set of person who would have a right to your goods then, or your assets, would be your brothers and sisters of the whole blood. So, you know what whole blood means, right? It'll be your brother and sister on both mother and father's side. So, this is how you realize it is so important to make a will, because a lot of times families don't even get along. And you don't even want what you have to be passing to maybe a brother or a sister who perhaps, we're not encouraging people not to get along with people. But sometimes you might have had a really good friend, or this is the church. You could have left something for the church so that the church is enabled to help the community more. You could have left it. And I say amen to that too. You can leave whatever you have to organizations, companies, whoever you want. It must be your intention, and it must be voluntarily that you make whatever dispositions. So first, the brother and sisters of the whole blood would have a right now to that residuary estate. Now, if there are no brothers and sisters of the whole blood, then it goes to the brothers and sisters of the half-blood. So you see how things can sometimes leave from a family line and go over into a next one, because that brother and sister who is of the half-blood, if maybe it's one person, after he gets it and he has children, it goes the next direction again. And it wouldn't be going down in that line that you may say, boy, we want this house to stay in the Joneses family. But because his daughter might be Smith on her mother's side, by the time she gets in possession of that property, then she gets married, something happens to her, property gone out of the Joneses family. Not even the Smiths would have it then, because husband now will get his life interest in the property. So it is so important for persons to do things and think seriously about ensuring that when you have considerable assets, that they're well provided for. Now, if there are no brothers and sisters of the half-blood, the next set of people who have a right to claim your assets would be grandparents. And it does happen, because sometimes people die young and the grandparents are still around. Things could happen where maybe a family might have gone on an aircraft, and for some reason something happened. It could have taken out mother and father, just like that. So only grandma and grandpa could have been there to inherit something, because mother and father and maybe the children were on the flight. And right away, grandma and grandpa, they have their right under the residuary estate. And this is passed to them. If more than one of them, it must be equally distributed, so it will be in equal shares. Fourthly, on aunts, uncles and aunts of the intestate. And there must be brothers and sisters, here it goes again, of the whole blood of a parent of the intestate. So these whole blood and half blood is extremely important under the law. Fifthly, where all the others have failed, uncles and aunts of the half-blood would now get a right to this residuary estate. If there are no uncles and aunts of the half-blood, then the surviving husband or wife absolutely would get every single thing. So he'll get the property, the chattels, you name it, everything will pass to him. Now where there is nobody at all to get anything, which is the default, in default of any person taking an absolute interest under the provisions of the residuary estate of the intestate, this passes to the crown. In lieu of anybody having any rights to that residuary estate, the government then, the crown, will get what you had. And that's called, in law, we say that it escheats to the crown. Now, can we see why it is necessary to make a will? Where a person has assets and or interests, among other things, you realize how under an intestacy, how complicated it can be. And if one dies without the will, the law simply dictates the dispositions of your assets. This may certainly not reflect the intention of the person who died and who would have never wanted certain persons to receive the assets that they would have gotten just because there was no will in place, and because of that, the order on the intestacy had to take place. Now, after we've spoken about what is a will, whether it's necessary, if you don't have it, that your assets, your equity, and any appointments, all these can fall under an intestacy. We are now looking at our youths, and we are saying, can a young person make a will? The simple answer is yes, they can. And by answering that question, it begs the question, who then can make a will? And it is anyone over the age of 18 years who has considerable assets and is of sound or competent mind can make a will. And soundness of mind is important because there are many times when persons are making wills, and it's not because they so wanted to make a will, but because they were not in their sound minds. They were influenced to make the will. And so the law is very, very particular about someone being competent or of sound mind when a will is made. Now, a young person needs to make a will because no one knows when the time to depart this world will come. And so estate planning is a necessity, as young persons also die. And I always use the example of Kobe Bryant, who died in the prime of his life. And I am sure that we all know many other young persons who were not celebrities, but it's just a truism. When your time come, it come. And so some persons' time will not allow them to reach to the 70+ years. Some go relatively young. And there are some young persons who amalgamate wealth quickly. It could be because they might have gotten into some sort of business that they were able to make quick returns on the monies that they invested in their company, or it could be by way of inheritance. Because, a lot of people, they're born into great wealth. So even though they're young, they do have great wealth already. They're trust fund babies that exist. From the minute they're born, the millions are there. We may not have the millions so much here, but we do have quite a good amount of persons with substantial income, and they have property, They have all sorts of other assets that can be disposed of in their wills. And so, yes, young persons can make a will. Now, the question is, what are the requirements of a valid will? The maker of the will should, as we just said, they should be 18 years or older. They should be of sound mind. They should be making the will without duress, that is voluntarily, without pressure from family, friends, or caregiver. Because it is a sad thing, but in so many cases, especially where a lot of old people are around, persons who simply start to take care of them, they start to put all sorts of ideas in the people's head that, like, it's time to go home to Jesus now. But it's time to go home to Jesus now, but at the same time, they look in the personal property. And they might have their children who are abroad and sending monies and helping them and expecting that mommy has made her provisions already because the new will was done. But because of the ambulatory nature of the will, here is the caregiver who can call in somebody while the family is abroad, and they get another will done. So when that lady dies now, the family is left perplexed because they're thinking, okay, well, we hired this woman to look after mommy. We didn't expect she would be getting the family home that we so treasured and saw this as a legacy, you know, that would have been passed on in our family. So yes, some people are pressured. Mind you, there are also instances where the caregiver actually take better care of the person than the children too. Because some children, they don't look back, and the person may genuinely care for that person, the caregiver, so much, and appreciate the help that the person is giving them, that without any pressure or any duress, that person just decided, you look after me, or are you looking after you? Simple as that. And so that is why the court is left sometime with quite a balancing act, because the court will then have to determine in circumstances where people now would want to contest the will because the family going to be saying, but it's my mother's house. How she expect to come and get this? And so they might be trying to contest it, but then when evidence is led in court, that's where the judges would be able to make the determination whether or not the rights would really pass to the caregiver, or the will, once it is contested, whether it stands, the application that was made, or it fails. So we are talking about requirements of a valid will. And so we look at the will should be in written form, because it is your instructions as to what ought to happen upon the demise, upon your passing, and so you want to ensure that it's recorded properly, so it's written down. And after it is recorded, the testator, remember the person who makes the will, is called the testator. He must sign the will. And this will must be signed by the testator in the presence of his two witnesses. And they do that because you want to ensure that not just one person is there, so that one person could just be in cahoots with whoever in the house and they just witness it. So you try to get even two persons thinking, okay, this would give a little more balance, because I don't think whole two people going to go and encourage that person. Yes, it can happen still, but the two witnesses are required. Now the question is, having made the will, should I tell the people who are the beneficiaries what the content of my will is? Let me hear you. Now, why you say no? You think they're going to send you over quicker? And you know, this happens because it is your choice as to who you want to benefit. But sometimes just by telling the beneficiaries, people behavior change. Because if Mary looking after you well, and she said, oh, is Jane, she getting the property? And I hear walking out my stomach. Then, you know, Mary behavior kind of, she start to ease back. She's not going to do as much of the things that she was doing, because she's thinking, well, she ain't got it in to give me nothing at all after all these years. And it is sad, because you don't do things looking for anything. But because the house involved, and people see house as great wealth, in that if I get this house, I don't have to put myself in any debt to go to the bank and borrow money when mama house right here. I have a nice 3-4 bedroom place I would be moving into. So poor old lady going to say, well, you know, June sending the money monthly, and so I put down she name. Then Mary changes, and then it can make life very difficult. In fact, I know of an instance where this man, he actually told all his children, you know, what he had for them. And he was a very lonely man after, because who wanted something didn't get what they want. And it was sad. And so that is why I do agree with you. Don't tell them a thing. Let everybody work hard, because they want to know what mommy going to give you or what daddy going to give you. Let everybody work hard if it's that driving them to do what they're doing. Because that shouldn't be the impetus. But if that is the case, always ensure that the contents of your will are kept private and confidential. Of course, this is completely up to the testator. However, it is advised that one would use some caution in telling persons about what is in there. Mind you, you do have good children too, who you can depend on, who you can trust. And you know, I tell them, and I'm safe, this is a good person. I've known her for my 25 years. I had no reason to doubt how she handled my finances, how she deal with my matters. She takes care of my house. I would know, even though I have 4 children, that's the one I want to give my property, because I know that me passing on, she's going to take such good care of my house that they will say, oh, boy, that was Gumbs' place, you know, you see, still looking nice. And sometimes for some people, that means a lot to them, knowing that even though they've gone on, that their loved ones would be the one taking good care of the property. Now, we look around us, and you see a lot of dilapidated properties all around. A lot of them are run down. And a lot of the times, it is because of confusion that was left. No adequate provision was made for Mary to get the house or John to get the house. So mommy says, share it up. And by saying, when you share, when I gone, everybody could live in it and whatever. Then Mary says, sell it. I want my money. Then John said, no, man, mommy live here a long time. Let me leave it and make it a family home. And then somebody else has another opinion. So, you know, when everybody is at loggerheads, some just turn off, don't do anything, and then everything is just left there to rotten down. We see this over and over and over and over again. So it's important that provision is always made for one's assets that they have. And in making the provision, you do it wisely. Because leaving a house to too many people is just, it can lead to a lot of confusion. We've had instances where on the road, even on the road, 2 sons get a property and one feel he has more right than the other. And so he starts to build around in the house, and the other one can't even get access to the home anymore. And here is a father who would have thought, oh, these are my 2 boys. The property passed to them. But different personalities, and it becomes chaos. So it's important to really do that balancing exercise and weigh in your minds what really is the best choice I have. Now, having made the will, you'll be wondering, where should I keep my will? Because you don't want everybody to know what's in it, so you want to make sure it's secure. And so, you can pay a small fee, and you can leave your will in the safety deposit box at a bank. You know, they have safety deposit boxes where you can safeguard your documents, etc. Of course, you can have an area in your home that you designate as, that's the place I'll put my will. Anything happen to me and they search up the place, they'll find it. And mind you, there are people who you trust too, that because if you trust that particular person, you could have a key and maybe it locked away in something, and you say, anything happen to me, just use the key, open the 3rd drawer, and keep my documents in there. You can leave the will at your solicitor's office. And there are other options that can be more applicable to individuals, maybe at a friend's home who you may know that person may have a vault or something and you trust them and you think you could leave it in there. In other countries, people actually provide services where they actually safeguard these documents for a fee for people. No, this is COVID. Maybe the church needs to do this sort of thing, get a big vault and start to charge a little fee and secure some documents. I mean, sometimes these are the little things that can lead to some real financial returns, or what of you who come to the church can start something. Because I don't think anybody else except, the solicitors or leaving it at your home also provide that sort of safety mechanism for persons to leave their wills if they so care to. Now, the question is now, having made your will, after the testator passes off, what can one do if the original will cannot be found? Because, you get an original will. So, some people are older and in their old age and they're moving up things. Sometimes, you can't find anything. They might have moved homes or something, or for some reason it went somewhere and they can't find it. Well, in those cases, a copy can be used when applying for the grant of probate in certain instances. The court, upon allowing evidence that the copy is a replica of the original, will in its discretion can admit such a copy of the will to allow the probate of the estate. So you see, our judges are not so hard and fast in all instances, because they know certain things can happen that can cause one to be in a situation where things are just lost, and you want to make sure that the dispositions of the testator can be carried out as best as possible. Now, we spoke about whether a will can be updated, when I said yes, it can. And this can be done by way of what is called a codicil, where any amendments that one wants to effect can be done via the codicil, or you can simply just do a new will. Because for the wills, the last one in time is the one that prevails. So whichever is your last will, that is the will that stands. And even in the will itself, when you're making it, you're going to say that you renounce all other wills and etc. that was made. So the last one in time is the will that will take preeminence, and that will be the one that matters. Then we are wondering, can a will be contested? And yes, of course, people will challenge things when they think that, boy, I know my mother wasn't so solid. So then you're going to say, well, something ain't right. That wasn't mommy's signature. And because of that, persons would have had maybe another will before that they would have made. And what happens is that if a challenge is made to the last will, because we are talking about if a will can be updated. So if the person had a will before, and then you challenge that last will, what happens is that the will from before can stand in certain instances, because if that old will is revoked, the last one, the one prior to that, can be deemed to be the correct will of the person, because you would be saying, that was the will that really was the correct will the person did. This one is a fraudulent one. So because that is a fraudulent one, then they will revert back to the other will. Hopefully that they kept a copy of it as well too. So yes, wills can be contested in certain instances where there may be allegations of fraud, among other things. And so that is why, although other persons may assist someone to make a will, because yes, you can assist someone to make a will, but the important thing is that you have to know what the legal requirements are. And so, once you know what the legal requirements are to ensure that a valid will is in place, one can be the person who helps to draft that will, and see the person put the testator sign, and in the presence of two persons, and they safeguard their document. However, as an attorney at law, it is highly recommended that you go to your solicitor to have such a document prepared. Because you don't want that, because the person was helping you, that certain things were not taken properly into consideration, and because of that, your wishes were not properly effected. That is not to say that persons have not done wills outside of a solicitor's office and they have been done quite well, and they've stood up to any challenges that have occurred in the court. But it is highly recommended that you contact your solicitor and you ensure that your gifts, your dispositions, that they are actually taken into consideration in your will in such a manner that the least challenges that can occur will happen. Because you don't want to leave the confusion behind. You just want to know you've passed this way, you've gone, and everything just went good. Who you wanted to get what you want, they got it. So yes, remember the church, remember other organizations. It's not just family and friends that can get everything. We have to learn to give things more in the community so that other persons can also benefit from what we have, if we can. We try as best as possible to do so. Because of course, some people have your families and you want to make sure that whatever you have would pass to your child or whatever. But some of you have quite a lot. And so that property that is on rent, apart from the one that you live in, you can say, let me give this one to this organization, this church, this, you know. These are the ways that we can give back and leave a legacy behind and ensure that the will speaks from beyond the grave. I hope that I have given you some information that would be of some assistance to you. And so I thank you very much for your time and your attention. And if there are any questions that are burning, feel free to ask. Oh, and I must add also that, you know, there are many expatriates who live here in St. Kitts. You have persons who, they may live they have their homes in the UK, but they're still here. And so if something happens and you have property in one country and you have property in another, the law provides that after a grant of probate has been applied for in one jurisdiction, rather than you have to go through the whole grant of probate process again, that one can apply to do something that is called resealing of the grant. You know, once you get a grant, a seal is put on your document. So once an application is made by your attorney at the other jurisdiction, they can just reseal the grant. So whatever was given over there, the court will have the documentation, reseal it in our jurisdiction, and then whatever wishes then that the testator had, the dispositions can then be made. I think it's important because, you know, people are traveling here and there between jurisdictions. And let us take what I've said to heart about ensuring that we do our wills, because, you know, look at COVID. So many persons, so young. And see, not just the old ones, so many persons have passed on. And I'm sure that there are a lot of issues now that would be left because a lot of people would not have even considered, let me do a will. Because it's not something that one typically thinks of. And it's not because we're thinking of dying, it's just that we're thinking that I have assets and I want who I want to get my assets, that they're the ones who would get it. So whether it's that the assets pass to them when I'm 26 or 96, at least that is my intention, that I wanted that person to get it. So don't be concerned about the fact that if I do will, it sounds so final, as if like a soon go. Because I've had people come in the office and I've had people, when they come in, they tell me, I'm ready to go now. And I'm saying, go where? I actually even make a joke and say, it's the ones who make the will seem to live the longest. So, you know, so it's always about adequately providing for our loved ones. Thank you so much for your time and attention. Good afternoon. Yes. Once you have that motor vehicle that you mentioned in the will, for any reason, if that vehicle changes, you will have to do either the codicil that I mentioned, or he'll have to redo the will. Once there's any items, like if a beneficiary dies, suppose you had a beneficiary named in the will, but the person died even before the testator, you'll have to do the codicil or do over a new will, because you see, you cannot be passing things to people who don't exist. Just like how that vehicle now that was mentioned, it was no longer that vehicle, then the gift can't pass, you see? So it's very particular that you ensure that whatever you are leaving, it exists. And for any reason, if there are any changes, that the codicil or a new will is done in the circumstances. Yes, please. Yes, I'm hearing you. Yes.
Before it is determined, if someone passes, before it is determined by the court who would get Tom's vehicle, would that vehicle automatically go in the estate of Tom Jones, or would it remain as Tom Jones? I'm not sure if you're understanding.
No, repeat that question.
Okay, so Tom dies.
Tom dies.
He has not left a will.
Yes.
So it still remains in Tom's name.
Right.
Nothing, the court has not determined who would get what as yet. Would that vehicle belong to, automatically go to the estate of Tom? Could you explain a bit more what the estate of someone means?
Okay, the estate is anything that is left by that individual that he mentions in his or her will that forms part of his estate. What happens is that if there was no will that was done by Tom, then what would happen is that a grant of letters of administration would need to be applied for by the personal representative of the estate. Now, remember we went through the whole thing about intestacy, and so by going through intestacy, if the chattels can pass, and so because that falls, remember when I listed the chattels, you heard motor vehicles were mentioned in it, so these will fall under the intestacy. So based on the order of who would be able to, if the issue is alive, or if the husband or wife is alive, and if they are done alive and it goes down the residual estate, then it will pass on to whoever would be the one who would be able to get it. If not, once there are letters of administration that are done, and by the way, was the car in a joint purse? Was it in a joint name? No. Just his name only. Okay, so it would form definitely part of his estate. Sure. Oh, and before you ask, something that I know is important for people to know is that if you have accounts in the bank, and I know people would be concerned about that, it's joint with somebody, you don't really have to, in your will, make any provisions for that, because there's a rule called the rule of survivorship, which means that the person, it's a joint account, and you're basically the beneficiary of the account, it should automatically pass to you. Unless there is, of course, some contesting of the will where somebody is saying it's just for convenience, the money was placed here, and then it becomes an issue that can be contested. But under the rules of survivorship, the other party normally gets the money. Just like if you have an insurance policy, once there's a beneficiary named, that person automatically gets it and it doesn't have to be included in the estate.
It's also important to point out that it's not just the bank account or the insurance. If there's real estate that is jointly held.
Of course, that again, yes,
there.
yes, definitely. Because once it's jointly held and it says, from me to you, the same rule applies, which is the rule of survivorship. Once it's a joint account that is said, joint account meaning joint tenants, because there are also joint accounts that can be held as tenants in common, where it's a tenant in common, it's not a matter of as soon as the person dies, it passes to the other one. The tenancy in common, we look at ownership in percentum. So I might own 65% of something, somebody owns 45% of something, and somebody could, under their will, they could be passing their share to somebody else. So the law is quite interesting, and we need a lot more probate attorneys. So hint, hint. Any other questions?
Yeah. Good evening.
Good evening.
I had a few, but I'll just ask some. Well, maybe one or two. I know you talked about the will, but could you give a little idea how much doing a will, making a will, and changing a will would cost?
Well, because I work at Legal Aid, I must admit that I'm not too au fait with the fee schedule that is utilized by the persons at the private bar. Because at the public bar at Legal Aid, I only charge a very small fee to do a will because, it's means assessed. And so if there are some persons, if based on what their means are, or they're unemployed, or we look at these factors, we assist people with wills and we do some for free, some they might pay $150, but, Legal Aid is a unique creature that was created to help the persons in our society who are really cash-strapped, can't do any better, but need some help. But at the private bar, there's a fee schedule, and attorneys can set their own fees within the scale of fees that the court allows. So I'm not in a position really to give you that. You'll have to make some calls.
Okay, the Intestacy Act. How can we get a copy of that act? Is it online?
Yes, it is online.
On the legal.gov?
You can go, what site is quite informative in terms of showing you the acts. I don't think you may be able to if you download it, I don't think that you'll be able to copy and paste.
Is on the Law Commission?
The Law Commission, yes.
Okay, I know that website. Okay,
yes.
That's cool. The other thing is, I think you
and that falls under the Ministry of Justice and Legal Affairs, my ministry that I'm in. So, we are proud to know you can get it free there.
Yes, yes. I get a lot of acts from there. That's where I get a lot of my legal.
Excellent.
So, but I didn't remember see that one, but or maybe I saw it and I didn't know what it was. But you kind of touched on it. But someone not in their right mind per se. But I guess maybe you might not be able to answer it, but well, they may have had intentions to give their property or something to their children, and they may now have a wife that's not the children's mother. But the intention, was to give it to the children, but maybe they're not in their right mind. Is there something in place to help them in that sense? Or if they're not in the right mind, it just goes to their wife, then it comes back to the same thing that you mentioned, well,
yes.
Goes out of the family. But knowing that was the intention, first of all, nothing is in place for that?
And you see, intentions can't go to court, you see? So it has to be the specific gift that would have been done in the will. And if they're not in their right mind, a person who is not competent can't really be making good decisions.
Okay,
so it's best to always, and that's why, do the things while you're young and strong and in the sound mind.
Yeah. And let me say before I leave, I think this presentation was well done, and I'm glad I was here.
I'm glad too. Thank you.
Yeah, you never know when you die, and you use Kobe Bryant. That happened to be my favorite basketball player, and when he died, it was a shock to me.
Exactly.
But my last question, You mentioned these scenarios you're going through there. When you have no issue or no parents, right? So you have no children, you have no parents alive, and subject to the interest of a spouse. So I'm assuming you have a spouse. So are you saying if the spouse is not interested in that whatever the property, residual property, I think you termed it as, are you saying then that's where those other, the firstly to sixthly comes in? Because, or is it that the husband or the wife has, what I should say, ultimate benefit power, if that is something? Okay, what happens is, remember, the spouse gets a life interest in the property, right? And the residuary is then distributed according to what the formula is. So what happens is he will get the life interest, he gets a portion of something, but he doesn't get all. It's only when there's nobody else who would fit in the criteria that he gets everything absolutely, you see? And it has to fall all down the line with everyone that I gave you, whether the intestate leaves issue, but no husband or wife, if the intestate leaves no issue, but both parents, and so it goes right down. So yes, it's important. You need to get a copy of the act because you'd be amazed to know how you work so long, you work so hard. And I don't know if Pastor, we don't know about spirits looking from beyond the grave, but they said there are some people who haunt people. I don't know if it's true. So we don't want to go there. So let's do what we have to do and do it properly. Sorry, you wanted to say something, ma'am?
Yes, Ms. Gumbs, I have a question.
Yes.
I think at least two.
Yes.
I know earlier you mentioned if the person, which my friend was just saying here, if the person is in their right mind.
Yes.
But what if the person is in their right mind and they make it known?
Yes.
I want to give my property to Mary when I die.
Yes.
But because of financial issue, that person wasn't able to make a will. It was not written. Can, let's say, marriage take whoever it is, the family, to court because they have evidence that, listen, I want to give Mary my house because you guys wasn't really looking after me. Mary were looking after me.
And that's why it's so important that the person does what they have to do while they can. Because once there is no will, the Intestates Estates Act steps in.
Okay, the next question.
And not cutting you off. And you see, if the sound mind factor, you know, most persons want to challenge that. You can have their doctor see them even before they decide to do whatever, so that doctor's report can be there that they were examined on this day, they were found to be of a competent mind, whatever. So if somebody down the road, the family who ignore them, want to challenge it, the records would be there to show she was very lucid.
Okay, my next question.
Yes, please.
If you have an only child, you're not married, and the person die, no will, can somebody, let's say a family member, challenge, maybe, I don't know if that's the right word, challenge the child to say, well, listen, I helped do this, so you cannot get all of it. Can anybody challenge that only child?
Okay.
If anything happened?
When you said that, it was like a family property? With other person's name on it, or just
no,
the
it's
person's just that individual's name on it?
Just one person's name on it.
They will have a hard hurdle to challenge that and get behind it, really, because if it's just your name and you purchase something, it's your only child. The child will just have to do letters of administration, apply for the letters of administration. They'll be the personal representative, and there's nobody else. Because if you're not married, there are no parents. But your parents would have been alive? Okay. Because remember, once it's the only child, though, no spouse, The parents are there. Though. Remember, parents and the issue still ranks ahead of the parents. So your child would be all right. But what you need to do is that where you can make provisions for your children, even before the will stage, if the child is of an age that you can add their name on the certificate or title, you can do so. Of course, you have to be careful too, because, you know, everything is a balancing act. You can add people's name and then you get a nightmare. Only child or not. Hopefully not in your case, you know.
Thank you for beginning that discussion, because that's the first question that I have. What if you don't make a will, but you added a name to the certificate of title and you passed, you didn't make a will? How successful would a challenge be to that person who you place on the certificate of title?
Not very successful.
Not very successful, okay.
Because the rules of survivorship applies, especially where there's a joint tenancy. One dies, it passes to the other automatically.
Right. Now, what happens if there are several surviving issues? How do you go about applying for letters of administration? How do you decide who should be the person who actually does that? Let's suppose in the case of children, and there are several children, and you know that the deceased did not want, let's say, John to be the one responsible. You know that. How do you deal with that?
Well, that's a challenge that is sometimes really understated. But what happens is that once you have a personal representative, one of the children who decides, I am going forward with this, it will require the others to consent to that person applying for the letters of administration. So if the others decide, I don't want Johnny do it, let Sally do it, all others can then gravitate towards Sally being the one who will be the personal representative in relation to the letters of administration. But then Johnny might decide, maybe not sign none because they didn't want to sign when I was doing it. And if they do that, the court then can intervene, because the court doesn't want one person simply having everybody in limbo. So if one doesn't want to agree, there's always a measure that one can take so that the matters move along in the system.
Ms. Gumbs.
Yes, please.
I have two questions. The first one, just to follow up on what Pastor Condon.
Since you're close to the mic and 6 feet from everybody, kindly remove the mask so we can hear you clearly, please.
I'm sorry.
Appreciate that. Thank you.
Yes, I have two questions.
Yes, please.
The first one, just to follow up to what Pastor Connor spoke of. My wife and I, say, for example,
yes,
bought property many years ago, and one of us passed. I remember I said many years ago. Can someone else still come and challenge for that? A different, another individual come and challenge for that property?
Your wife or you
got... Is in title in both of us' names.
Yes. Oh, no. If the title is in both names, no, they can't get behind that title. It's a joint tenant?
Yes.
Okay, they can't get behind that. The rules of survivorship applies.
Okay, thank you. My next question is, several years ago, I was friendly with a gentleman, and he told me that he was having a problem with his wife and that he's not going to make a will. And he said specifically he's going to let them fight.
Yes, some people do. Some do that.
So my question is, can the children of full blood, what can they do, knowing the situation, what their father said, what can the children do to make a change or bring some effect in their benefit?
Well, all they have to do is to simply, he did make a will, they'll need letters of administration, they just agree. One will be the personal representative to go forward and get it, and whatever the estate has, it's shared equally between them. If it means that they may have to sell the property and that one don't go in because it's confusion, if one gonna get it and not the others, they may end up having to sell the property, and that is why, these things have to, I guess he doesn't mind if it's sold because he said let them fight. And that will be a consequence of the fight because if I fighting over something, I want my money. That's what most of them gonna say. Most of them gonna say, I want my money. May want a confusion place.
Okay, thank you.
And so it is sad because, you know, it's important for people to really always think of not leaving the dead left, the confusion.
Good night.
Good night.
Thank you for the wealth of knowledge, Al.
Thank you.
It's interesting because I love law. I always wanted to study law. So
You better do it. You better do it.
But you said some things that has me thinking. No spouse, no issue. The mother and father equal.
Equally. Mm-hmm.
If a father or one of the parents is not or wasn't actively involved in your life, it's still equally?
Still equally. Still, so that is why you do the will.
Okay. Can the parent who was actively involved contest? No?
Well, you see, if there is no will, how do you prove actively involved?
You live with me.
Because you're the one who would most likely be able to say what happened and you wouldn't be around. So that is why it's important that whatever is done, it should be done while people are fit, strong, have a sound mind, to avoid all these pitfalls and to avoid people who you never envisioned to end up with what you work hard for.
Okay, now I have about 10 questions for you, but I wouldn't ask you all.
Seem like I need a meeting with you?
Yes, you do. If you have a minor, I know that you cannot put the minor name on your will, right?
No. What happens is that whatever you're leaving for them, it can be in the will, but you'll be held upon trust for them.
So you cannot appoint somebody? No?
So if you want to say X, Y, Z is for Sally, somebody will be appointed as the trustee, or the court appoints a trustee to administer the funds in the account, because you don't want people to just, as we do say, whack off the money and the child don't get what the child is entitled to, you see?
Okay. On a more serious note now, if you're married, let me just be more realistic. My husband and I, we have one child, and we've been in discussion about our property, our house. And I'm saying to him, I would like to leave my house and my child, not that if I die, you will marry. I mean, I'm not saying that you can't remarry. You can remarry to whoever you want, but
yes.
I don't want that spouse to come and get, our property.
Yes.
I want to leave it for my child. How do I go about that? Or
you can do your will, and your husband can have a will. So whoever goes before the other, that person and their will then be the operating one. So if you survive him, whatever your wishes are, it's already in your will. It passes to your child and whatever.
And she doesn't get it, right?
Sorry?
She wouldn't get anything, right?
And I'm sure that he would be making provisions for the child in his will as well. So it is good when both husband and wives that you do your wills to make sure that, God forbid, something happens. And the two of you could be going somewhere and something happens too. Huh? Not that we wish it, and we rebuke that in the name of Jesus. Yeah, sure, you may. Sorry, ma'am. I'm sorry.
She just said.
Yes.
Let's say the property is held as tenants in common. And he doesn't make a will. But she made a will for her part to go to her child.
Her portion can pass. Her portion can pass.
To the other part?
The other part
is for the husband.
He can only be the one who determines his portion in his will. That's the tenancy in common. You speak to your part, I speak to mine. And that's why when it's a tenancy in common and you own it in unequal shares or equal shares, it's going to be a difficult thing. So that's why it's best that when you hold property, you hold it as joint tenants. The tenancy in common thing, the more apply for like businesses. When people in partnership, because, at the end of it, they will just sell off and get their interest out of it. But for individuals, you'll tend to more have the joint tenancy where one goes, the other one benefits, as opposed to be holding it in whether equal shares or unequal shares. Yes, you can have your will, and in your will you have it for your son, and he can do his will, and in his will he has it for his son. So anything happens, sorry? No, it's recommended you both do different wills. Because suppose something happens, if you go before him, your name would be in a will saying that you're deceased. So it's preferable everybody does their own thing. Even though some countries do allow it, there are some countries where they can actually jointly do it.
But, sorry, I'll come in now. But let's say back to her case, right?
Mm-hmm.
He has a child that's not hers, and the same thing she has a child that's not his, and they want to will the property.
Mm-hmm.
So what may happen is that she will her part to her child, and then he will his part to his child.
It's apartments? Or it's just a...
No, one house.
Well, this look like you need... I'm not even too good with the Bible, like when you had to cut the child. Yes, I can't remember. And so that is why it's so important. It takes a lot of thought with what you have to do when you're making these decisions. Because you would want to cater for your child. He would want to cater for his child. Would it be best if, then you ask yourself, would it be best if both children even coexist in the same home? Maybe if you put them both live under the same roof, in no time they'll sell that house. So, you have to be practical when you're making these decisions. Because if I live in a place where I'm not really, the children are of probably not an age group where they even grew up together, they weren't, around each other all the time, they wouldn't have that bond. Not that they don't love each other, but that bond wouldn't be there. And so sometimes you have to really weigh. The one who I would think I would see as most responsible and the one who would take care of the home and the one you could rely on, that's the one who would get the property. And then you have other things that the other person can get if needs be. Otherwise than that, you may have to think of equally having it, the property can end up just probably being sold if it's shared up. Unfortunately, young people too. They say, I live with she, what craziness to do? Say, me want my money. This is what can happen, I mean, there are other instances where they can coexist well and stuff, and then, hey, you can add names to your certificate of title too, you know that? You can do a deed of gift so that you pay a smaller fee and you add on some of your family's name and so, but you see, you have to be so careful because when things break down for any reason, if you have a decision to make with your property now, with your land, have to be relying on everybody now to be agreeing with you about your own property to make a decision. So it's a serious balancing task. And it's not an easy thing that you just think, because I don't want to do a will, let me put on somebody's name on my property. Because you put it on, unless they give consent to move that again, you get wet. And nobody easily do move to give no consent to get no name off nothing. Trust me, I've seen some people who have been some really reasonable people, and then when it comes to somebody dying, you're wondering if it's the same person that you knew. People like that get crazy when money is involved sometime and property, Sorry, dear. My apologies. Please go ahead.
Apology accepted. Good night, Ms. Gumbs. Thank you so much for a very informative session.
Thank you, too.
Question. If a person dies intestate and had a lifelong partner not married, let's say they invested together in a property, they lived together for like 30 years, no children. I noticed the law speaks of husband and wife.
Yes.
Is there any recourse for this spouse who was not married?
Unfortunately, in St. Kitts, we don't recognize the unions other than marriage. There are countries in the Caribbean like Barbados, Jamaica, some of these jurisdictions, Trinidad, they recognize these unions. Unfortunately, we still adhere to the sanctity of marriage. And so because of that, one has to make sure that when you're doing things that you prepare in advance and not wait for any eventuality that would leave someone not looked after, as we would say. So make the dispositions, do what you have to do while the person is fit, strong, you're fit, strong. You make sure whatever you have to do, and maybe what you need to do is tie the knot. You're welcome.
Hi, good evening, everyone.
Hi, good evening.
Okay, I thought that my question would have been asked, but it's not, so let me ask it. Life expectancy of the will. After someone is deceased and a will was left, does it expire?
You have like a probate year in which you can deal with the matter. The executor or executrix of the estate, that's the person who would be responsible to ensure that the matter goes to court and who is to get what and who is to get, the dispositions get them. But you have a year, probate year. But even if things for any reason are prolonged, you just do an affidavit of delay. The person who is applying for the probate, they can file an affidavit of delay explaining why it took so long, to get around to do whatever. But usually it's a probate year.
Another question, sorry.
Yes.
Suppose you're not aware that a will was done. Can you find out from maybe the registrar or something?
Yes. If probate was done in relation to the matter, you can find out. But in relation to a will, because a will is not deposited in the court, but the person is holding their documents or it's left at a solicitor's office, only if probate has been effected that you will have an idea. And I must add that anybody who is a beneficiary under a will, you have a right to get a copy of the will. So if you know that Mommy named me in this will, or Tom tell me when he saw the will, my name was in it, you have a right to ensure that you get a copy. All beneficiaries are entitled to a copy of a will. Because some people do hold on it and feel as if only them to have it. But once you're a beneficiary, you must be entitled to a copy.
Good evening.
Good evening.
I guess you heard me before I came up because I was actually about to ask the same question. I had an aunt, she died in 2014. Mm-hmm. Apparently a will was left and we did not know anything of it until last year during COVID. Mm-hmm. When asked, we were told by her mother that a will did not exist. But being the PI, I actually found a copy of the will. My name was mentioned in the will along with a few other family members. My question is this. The date of the document, how important is it when it comes to making a will? That will was actually created a year and a half after I was born, and I think you mentioned it, where it will be upon trust.
In trust, right.
Or in trust, yes.
Mm-hmm.
How important is the date on that document? If it was updated since then, how would I know?
When you mean if it was updated since then?
If any changes were made
If there was another will?
Yes.
Okay. Once the person would have applied to the court for probate, you have the right, you can go over to the registry and you can do the necessary search. But if you know that a will was made, you saw your name in it, it's going to be hard for you to get to know about the other one if nobody talking, and if they did it at a lawyer's office, maybe that same lawyer they might have gone back to. So maybe you could go and ask a question and say, well, my name was in this will. Nobody has told me anything. And I feel that I am a beneficiary just as well under this will, because they could check and they could just tell you your name not in it. But if it's in it, you'll be entitled to a copy.
Okay, next question. If within that will there is someone that died 10 years before the testator,
then they can't take. It falls. And that will should have been updated. The mere fact that a beneficiary no longer exists and the testator is still alive, that will should have been updated, whether by codicil or a new will. Because that is why now when gifts can't pass under the grant of, once you have the will and gifts can't pass, the grant of probate now will then require letters of administration to be appended. Mm-hmm.
Last question, because I have a whole lot, so I might need a different meeting with you.
You might have to come and see me at Legal Aid.
Yes. When it comes to, insurance policies, are they normally mentioned in the will? is it mandatory for it to be, or it can be,
No,
can it be
once,
left
because
out?
insurance policies name a beneficiary, it's not necessary to put them in a will because the beneficiary is already named.
Okay. All right. Thank you.
Okay, you're most welcome.
Thank you. There is a question from someone on the Facebook feed.
Yes.
It's a Facebook question.
Good night. There are actually two questions. The first one would be, if you have a bank account with a named beneficiary,
yes,
and you make a will and name another beneficiary of the same assets, does the will supersede?
No. Whoever would have gotten their names on that same bank account, the law of survivorship is what should supersede, because the law of survivorship says if one person dies, the other one benefits. However, if for any reason there's something called a convenience test, if that person is taking the matter to court and want to contest it because they say, okay, your name was on my account, but it was just a matter of convenience why I had you down. It was my money all the time. I was the one who deposited, you would know that the person was the one who deposited their monies. It was just a matter of convenience. It was never intended for that. Then it's a challenge. And the court would then be minded to look at evidence to see what happens. But generally, it's the rule of survivorship that would apply, and it goes from one person to the next. Whoever survives the other account holder, it automatically passes to them.
Okay, thank you.
You're welcome.
Is from Shelley, if the testator has died and there is no one if the testator has died and there is no will, can the person who is next in line apply for probate? And how long should the person wait before applying for probate?
Okay, well, if the testator has died and there is no will, the issue of probate doesn't arise. Once there is no will, it requires something called letters of administration. And so the personal representative, they can then, with the consent of the others, of course, what I do is that I have people who would sign something so that they would say, in most cases, you'd want to know whether they are waiving their rights to their beneficial interests or not, because some people don't want anything and some people want their share. So that they will say, well, I'm a child of XYZ, but I waive all interest in this matter, in this property. So whoever wants to apply, the personal representative, they can do that with the consent of the others, but it would be by way of letters of administration, not probate. Have I answered you, or you need to get something else? Okay. Any further questions? Again, I must say thank you for your attention. Thank you for your time.
Ms. Gumbs, thank you so very much. On behalf of the Jam family, just among moms at the Antioch Baptist Church, we would really like to thank you so very much for such informative presentation. We appreciate everything, and you've given us a lot of information to take with us. And we want to thank you, and I hope that everything that was shared today, we would not just sit on it, but we would use the information because it was very valuable. So thank you very much, and I hope some of us would come to your office sometime. Yes. Pastor Connor.
Thank you very much, Sister Ursel. We want to thank Sister Diana and the Just Among Moms for organizing this forum this evening. And we want to thank Ms. Gumbs for doing a tremendous, tremendous job. And I would imagine that, of course, this is just the tip, very tip of the iceberg. And I am certain that those of you who have joined us in the sanctuary and via the various social media outlets, that you recognize that this is a very deep issue. I think, as Ms. Gumbs has said, it can be easily dealt with by just ensuring that you make a will, so the people you want to get your stuff, get your stuff. And so I hope that we would not delay, but we would do this tomorrow if you haven't done. And if you have one, of course, look at it if you want to update it, and make sure that you put the people who you want to be in it. And I'm glad that Ms. Gumbs also made reference to endowments, because I think in our jurisdiction, that is something that we have to begin to think seriously about in relation to endowments to charities and churches and stuff like that. But thank you so very much again, Ms. Gumbs, and I am sure that we will invite you back on another topic, another subject. I was quite impressed, of course, when you were talking about the young people and asking for money, and so you had all the finger works and the moves and stuff. So that's very good. Thank you. Thank you. Appreciate that. Thank you. And so thank you very much for joining us, those of you who are our followers on social media, and we look forward to your continued support. May God bless you tremendously.